May it please the Court, Tim Henkel for the appellate daughters. Your Honor should affirm the lower court's orders, not orders, for two reasons. There is no valid claim for indemnity as a matter of law. It's absolutely conclusive. Second, Your Honors, is there's no way that Your Honors can determine whether or not the trial court looked at the Cozell factors because there's an inadequate record on appeal. For either reason, Your Honors should affirm. First, on indemnity. On indemnity under the third-party rule of procedure, which is 1.180, and the second DCA's decision in Legary, there must be a valid indemnity, contribution, or subrogation claim before you go into third-party practice and bring new parties into a lawsuit. The appellant's position below was that there was no record that there was any such claim. There's nothing before this court that they ever asserted that they had any claim before the trial court. Further,
he said that some of the third-party claims were inartfully drafted, and he should be permitted to amend them to properly state indemnification, subrogation, and/or contribution.
He did, in fact, say that, but that's not correct because.
Counsel, if your arguments are true as to the lack of ability of him to really put forward a valid claim, aren't those things that should be contained more in a motion to dismiss after he has an opportunity to file it? You can then show why it should be stricken or dismissed.
No, because
you're calling for the judge to make a finding in effect in advance. You can never draft a valid complaint, therefore I'm making it with prejudice. Doesn't he get a chance to try, and then you can ask the court to dismiss it?
They did try, Your Honor. There was a prior motion to dismiss this very same claim. The prior motion to dismiss said you must state indemnity, contribution, or subrogation. They filed their amended complaint, still could not do it. Trial court, no record whatsoever that they ever tried to state such a claim. First time on appeal, they've now taken two different new positions. First, they claim in their brief, unlike the contribution, which is brand new. Never heard that any place in this record until oral argument this morning about a statutory contribution claim. The only thing that they say in their brief on indemnity is that they have under their constructive trust provisions, they've stated enough facts to give Your Honors an inkling, some speculation that there might hypothetically be a claim out there, and therefore you should leave to amend. But let's look at what the son sued the father for that now he's bringing the third-party complaint for. All of the three essential allegations brought by Harold Jr. against the parents, which they're now trying to seek indemnity or contribution for, all regard one trust. Look at the amended verified complaint filed by Harold Jr. And what he says in there is there were three wrongs, all regarding a trust called the Lizarraga Trust. They first say they improperly took the trust assets out of that trust and gave it to the mother. They first say Harold Jr. was promised that if he worked for cheap pay, that he would get assets out of that trust. And then the third thing they say is that the father and one of the sons, not the one who was suing, used the assets out of that trust to get improper loans and personally benefited. Now look at the indemnity or contribution claim. If you look at their own allegations below, what they say is that they're suing the daughters because they were trustees. The daughters are not trustees of the Lizarraga Trust. They're not beneficiaries of the Lizarraga Trust if you look at Harold Jr.'s amended verified complaint. How in the world can the indemnity claim, a hypothetical contribution claim you're hearing for the first time this morning, arise out of a claim where they're not trustees or beneficiaries? It's impossible. Plus, they never asked for leave to amend below. They never went to the trial court and said, Your Honor, if you want to dismiss this, give leave to amend. The third district has said, in I believe it's the Alvarez case, you can't wait to appeal to ask for amendment for the first time, and that's exactly what they're doing. They're shifting their ground. They didn't ask for it before the trial court. They come before Your Honors first in their brief and say, oh, it's under this constructive trust provision where they're suing for trustees where my clients are not beneficiaries or trust. How can we indemnify people that we're not even involved with? We have no dog in that fight at all. And then they also say this contribution claim, never raised below, for the first time raised in oral argument. So
Should they be permitted leave, though, to file an independent action? If, as you say, they cannot state an indemnity contribution claim as a matter of law, should they not be permitted to file an independent action?
Well, two reasons. First of all, they had that right. They've always had that right. They had counsel. They can go out and learn the law and file their claim. Second,
I don't know if they had effective counsel. We had counsel who waited 9 months. And I'm not so sure. Is that why the trial court dismissed this claim? Because they waited 9 months or on the merits? We don't have a record, so it's...
Well, we don't have a record. And the problem also, we hear it again in oral argument, that there's only one issue on appeal. There's two orders. There was two motions to dismiss, and they were both granted. If you look at the record on appeal, there was a motion to dismiss for involuntary dismissal under Rule 1.420 subsection B. But how about the other order? The other order, which is in the record on appeal, says that we're granting the supplemental motion to dismiss based on indemnity. So the court's ruled not only as a matter of law in one order that there's no indemnity claim, so that's why we got to dismiss as a matter of law, but also there's a second order saying involuntary dismissal because you didn't comply with leave to amend. Now let's go to that issue because to answer Your Honor's question about whether we should allow them amendment. The problem is that Your Honors cannot determine whether the Cozell factors have been complied with. There is no record on appeal. The burden of proof is on the appellant to come forward and give you an adequate record to show two things. One, that the lower court looked at the Cozell factors. You have to at least consider them. And second, that they somehow misapplied, the trial court misapplied the factors. There's no record, no transcript of the hearing, no affidavits like in all the other cases they say where the attorney came forward and said, I'm sorry, mea culpa, I did a bad job, or the client came forward and said, I didn't know anything about my attorney doing a bad job. You don't have anything. You have nothing at all to make factual findings of that the trial court abused its discretion. The problem is that...
You have an inherent suggestion that the client feels the lawyer did a bad job by the fact that clients rely on the lawyers and the lawyer waits 9 months to file a request to amend or change something.
Well, Your Honor, if you look at their own brief, they contend that the Kendalls are of advanced age, but they consider that they're Harvard graduates, that they're in full command of their faculties. We have a huge delay here from people who apparently, according to their brief, are desperate for
Brilliant
money.
business people and corporations, they still rely on their lawyers.
They still
That's
rely
why
on
you go to the lawyer and you put yourself in the hands of the lawyer.
and that's why we have...
Sometimes they're chagrined, but that's what you do.
That's why you have legal malpractice actions, Your Honor. The problem is there's no factual findings for Your Honor to make the determination whether the client was without fault. The problem is that the fact finding may have been made at this oral argument before the trial court, and you don't have a transcript. So you don't know whether or not what the factual findings were. The problem is the Ham decision is totally distinguishable. I mean, they come forward and basically say Ham determines the day. In Ham, and the reason they say that is because the two orders here don't have express written findings of the Cozell factors, and therefore this court should reverse because Cozell requires these consideration of these 6 factors. That's not what Ham says. Ham says that when you disobey a court order, you must have express written findings. Disobey a court order. This district in 2 cases, Seacott and the second case is Nezelik. In both of those cases, they say the failure to amend after you dismiss a complaint and the court gives you leave to amend, the failure to take advantage of that opportunity is not disobedience of a court order. Ham has no application here today. This is not a situation where they were told to do something, the trial court said you must amend, and they disobeyed that. The failure to amend is not disobedience of a trial court order. In both the Cozell case, no discussion that there must be express written findings. They simply said the trial court must consider the factors. And who knows if they did? We don't have a record. Maybe it was considered at the hearing, maybe not. This court cannot determine. In Ham, only if you're going to dismiss with prejudice because of disobedience with a trial court order like a discovery order, must you have express written findings. Nothing here that we're not talking about disobedience of a court order. We're talking about failure to state a claim for indemnity that they've had 3 chances. They had a motion to dismiss the first time, they had the trial court, and now they come to you on appeal. And they give up on implied indemnity, and for the first time, no argument. They now say contribution.
Well, since this is a dismissal of a third-party claim, is there any reason if this were affirmed that they couldn't file their claim independently? Why would it preclude?
It would not. They would have. That's the beauty of third-party practice is before you get into the door of all your other claims, you got to state one of the magic 3: subrogation, indemnity, or contribution. That's what the rule says. That's what.
But do we know from the order here, because it's a pretty form order. It tells what was filed and it's been granted. Do we know why? Is it dismissed because they cannot and are not stating a claim, or is it punitive because they wait 9 months instead of the 15 days?
There's 2 orders. One says, and it does all the things that Nezelik says you're supposed to do, it says motion to dismiss for failure to comply with 1.420 with prejudice. The court granted that one. That's one order, and that's the one they appeal from. But the other order, entered the very same day, says we're granting the supplemental motion to dismiss, and if you go back and look at the record, the supplemental motion to dismiss was failure to state
If you go
indemnity.
to the first one, which basically is, I guess, sort of an untimely dismissal,
Yes, Your Honor.
they have a third-party complaint. It is dismissed. They're given 15 days leave to refile.
Yes, Your Honor.
All right, they don't do it in 15 days, they wait 9 months.
Yes.
Aside from the fact that counsel points out, well, it should have said do it in 15 days or it would be dismissed. Didn't say that, but forgetting that, it does get dismissed, it does get filed 9 months later. There's a motion to dismiss, and it's granted. Why are they not in the same ballpark as you have, when a complaint is filed, you have a certain number of days to file. You have 20 days to file an answer. If you don't, you're subject to a default. But if you file your response a year later, but before the motion for default is filed, that answer is going to stand. Why are they not in that boat? They got their motion 9 months late, but they got it in before the motion to dismiss was filed.
Well, for two reasons in this case. First of all, they didn't have a valid claim, so that's one issue. And once again, there are two orders, two motions, and both grounds are up here before your honors. The reason why they shouldn't get the additional time is that we don't know if the trial court looked at the Cozell factors and concluded that a dismissal was the least drastic remedy. It is extreme. A dismissal with prejudice is extreme. And that's why the court said we're not going to make
It's
it
the ultimate sanction.
We're not going to make it the automatic sanction it used to be under the prior case law. What we're going to say is you got to look at Cozell. But this court cannot reverse the trial court because we don't know if they complied with Cozell. We don't know what the trial court considered. The trial judge may have made all the findings required by Cozell, may have had substantial competent evidence. We don't know. We cannot reinvent a record.
Counsel, your time has expired. I've allowed you to go over, but
Thank you, Your
grant
Honors.
a conclusion.
We'd respectfully request that you affirm.
Thank you very much. Very brief reply, Counsel.